In this module, we're going to talk about tenancies. There are a few different types of tenancies, so you need to understand which types of tenancy might apply in different circumstances when you're acting for a landlord and discussing these things with a potential tenant. So, first of all, what makes a tenancy? Well, a tenancy is a legal term for an arrangement between a person who wants to occupy a property for a period of time. It might also be called a lease, but in order for a tenancy to exist, then there has to be some rent payable. The occupiers have to have exclusive use and exclusive possession, and an agreement has to be in place as to the length of time of the agreement. All of these must apply for a tenancy to exist. Where one of them doesn't apply, there will be no tenancy, but it will be what is called a license arrangement, and I'll look at that first of all. So, if the arrangement is a license, then the occupier will not have the same rights or protections as a tenant. The person who is the occupier is known as the licensee. The person providing the accommodation is known as the licensor. So examples of a license will be a person who lives as a lodger, a tenant who has a permitted occupier. That permitted occupier will have the license. An employee who lives in a property where there is a company let. So therefore those would be licensees. Most common type of tenancy you can have is an AST or an assured short-hold tenancy. They're controlled by the Housing Act of 1988, and this legislation sets out to create a secure method of occupation for a tenant, whilst respecting that a landlord may wish to take back control of the property for his own use or to be able to sell it. So to have an AST, the following must apply. The tenant must be a person, not a company. The landlord cannot live in the same building or in a connected part of the building. The rent must be less than £100,000 per annum, and the property must be the tenant's main residence. If those things apply, we have an AST. ASTs provide tenants with a good degree of security. However, the landlord can recover possession, and they don't really have to give any reasons for doing so if certain situations apply. So the tenancy can and generally is for a fixed period of time, but no minimum or maximum periods are required. However, the courts will not award possession to the landlord until the tenant has had minimum of 6 months occupancy. Hence, ASTs tend to be for periods in excess of 6 months, generally up to a period of 3 years, but it can be longer. Landlords will have to give the tenant at least 2 months' notice if they want to take back the property, and the landlord can also ask the court for possession if one of the 17 grounds for possession under the Housing Act applies. Another type of tenancy is an assured tenancy. This is similar to an assured short-hold tenancy, and it's also created under the Housing Act, but there is even more security for a tenant under this type of tenancy. Typically, these types of tenancies are used for retirement homes, retirement communities, by housing association, where the landlord is less concerned about getting possession of the property back. The same criteria applies when creating the assured tenancy as when creating the assured short-hold tenancy. But unlike the AST, it's not very easy for the landlord to recover possession unless there are one of the 17 grounds for possession under the Housing Act that are available to the landlord. This type of tenancy can be created for a fixed period, but more often than not, it isn't. We also have non-Housing Act tenancies. These tenancies are ones that don't meet the criteria of an AST or an assured tenancy and will not give the same protection provided under the Housing Act. This type of tenancy is also known as a contractual tenancy, a law of contract tenancy, or a common law tenancy. Non-Housing Act tenancies are, for example, company lets. This type of let must be to a company and not to an individual person. The contract will need to be signed by an authorised signatory of the company, and as an agent you should get written proof that that person is authorised to sign on behalf of the company. And these properties tend to be occupied by an employee of the company who will be the permitted occupier. They're not controlled by the Housing Act, and there's far less protection there for the tenant, or in this case the licensee. Another example would be a holiday let. These are mainly found in tourist areas, obviously. They have specific rules mainly linked to the tax treatment of the rent that's received, and the average let for these type of properties is a week or two, but it can be for longer. The agreement used is a simple contract between the two parties. Tenants have very little security of tenure, meaning that a landlord can easily recover possession. To be considered a holiday let, the property must be available for letting for a minimum of 210 days a year, and it must be actually let for a minimum period of 105 days per year. And it mustn't be occupied by the same person for more than 31 days in 7 months of the year. All those things apply. We have a holiday let. We also have Rent Act tenancies. This category of tenancy encompasses tenancies that started prior to the introduction of the Housing Act in 1988. These tenancies provide the tenant with a high degree of security of tenure, which means it's very difficult for a landlord to recover possession of the property. These tenants tend to be known as sitting tenants, and they're long-term secure tenants, and the tenants have the right to pass on the tenancy to family members who are living with the original tenant at the time of their death. These are called succession rights, and as such, again, provide a very, very great degree of security for the tenant. Succession rights can only apply twice, so on the second succession, an assured tenancy will be created which cannot be passed on to any other family members.